conditions of approval. We want to reverbiage that one. All grading and drainage to the property shall be directed away from Lake Fork Creek and wetlands, period. Development will abide by BMP, and drainage plans will be approved by the Valley County engineer. And I believe in the CCNRs also, we talked about the HOA approving all of the interior plans, so I think that was in the CCNRs too.
Can I ask a question,
But I
Mr.
did-
Chair?
Sure.
Is this directed towards my development work, or is this directed towards the contractors who are building homes?
This is directed toward the lot owners, actually. So once an owner is in possession, I mean, they can only water half an acre. What we don't want is for them to turn on their sprinklers and allow all of that water to go over the side of the hill and into the creek. So they need to either retain their stormwater on site, drain it away from the creek. It's a protection to the creek.
So we have submitted a plan which has directional arrows that are consistent with this, because this is already a regulation that we're abiding by. We're governed by the EPA, where it's directed through DEQ. We have a SWIP permit, which is inspected every week. We're in full compliance of it. Wouldn't this better than, instead of being a development agreement provision, because the development will be done, wouldn't this be better in the CCNRs, so that the builder has a document that they abide by when they buy that lot? It governs them. My development agreement, they're not likely to be familiar with my development agreement, but they will be familiar with the CCNRs. And we want them to abide by this. It will be a condition when they submit their permit, so the county will reiterate this, but it just seems to me that instead of in the development agreement, the development agreement should have me put it in the CCNRs, so that they are given notice when they sign on that lot and they read the CCNRs that they have to be governed by this. And again, of course, they're still coming in front of the county with their permit, and you will again reiterate as a condition of their permit the same provision.
So 2 thoughts on that. One, we don't oversee CCNRs, so we would have no oversight of this without it. I mean, I think it should be referenced in both.
Okay, that's fine.
And I believe in your CCNRs, there was a reference that the HOA has to approve all internal.
We're fine with
Site.
either, Chairman.
Let's make sure it's referenced in both. I think it needs to be on the plat. I mean, as a real estate agent, I looked at every plat to see what.
It is in the construction plans, which were approved by Parametrics, your engineering firm. So, yeah, we obviously completely agree with this, and just however you feel is the right way to implement it is fine with us.
I think it does need to be referenced in the CCNRs, but I think, if I remember right, it was in the CCNRs that the HOA has to approve those internal documents. So. Number 10, we would like to change also. First of all, just a general statement. This is talking about dust abatement during construction. Construction does create dust, period. I'll just put that on the record. The developer shall comply with SWIP compliance, BMPs, and dust abatement plan, and comply with state and federal laws. And there are laws in place already about dust abatement. And so I think, we just need to make sure that I don't know what IPDES has to do with this. Haven't seen that referenced prior to. So I think, as long as you're in requirement with the SWIP, the BMPs, and dust abatement plan, and state and federal law.
Chairman, we have no problem with that. It's obviously redundant because we have an approved SWIP. Simon, the primary company in the state that oversees those and makes sure we're in compliance with them, we have an engagement letter with them. We have our SWIP currently posted. It's been approved by DEQ, which is, follows on the regulations of EPA. We have weekly inspections to comply with this, which we pay for. So we're happy to reiterate that, but there's no way we can be constructed without this. Every development has to abide by this.
I think because this is in there and is a disputed item, I think we leave it in. We just reverbiage it.
Okay. Well, there's no dispute to us. We are always SWIP compliant. We have our permit and we will remain compliant, absolutely.
We were told this was a disputed item, so let's leave it in there and just,
I think the extra verbiage that you took out, I believe was the disputed part. So by taking that out, you're just reiterating normal compliance.
and that's what we felt too, so.
It's, Madam Chair, the words will now read, the developer will comply with, and then it's SWIP compliance BMPs. Okay,
It has to be.
yeah, it was just, for the record, it was like, 3 lawyers working on a few sentences. Sometimes it just gets, and so.
It has to be everybody's worst day when you get 3 lawyers. I'm sorry.
I understand that.
Oh,
I take it as a compliment. Yeah, no, and so that sounds good.
we tell Brian that all the time. too. She doesn't take it personally.
No, of course not.
Okay, so now back to the clean agreements. So that references, did I miss anything?
I
Do you
don't
guys have
think so.
anything else to add to that part? Okay, so clean draft. So I want to make sure on number 1, I'd question, this is a long notification, but anytime you're going to do construction improvements on Spink Lane, 60 days prior notification before the commencement. Are you guys in agreement with that? That was accepted as,
Madam Chair, it requires the county to provide the notice, and so from the developer's perspective,
you're not going to be starting on Spink Lane anytime soon, so therefore when we get your permit, we'll go ahead and give 60 days.
it's fine with us.
Okay, perfect. The property shall be governed by an HOA, shall be governed with CCNRs that shall include but not be limited to provisions related to regular and special assessments, enforcement mechanisms, maintenance responsibilities, authority for the imposition of fines, lien rights, and other rights codified in the Idaho Homeowners Act Association. We're all in agreement with that.
Yes.
Property is currently fenced on Spink Lane with the general style of fencing previously submitted in the preliminary plat landscaping plan and shall be approved style of fencing during initial development. A CCNR shall allow individual lot owners to install fencing consistent with home gardens, dog runs, child play, safety areas, but otherwise prohibit perimeter fencing on individual lots except as otherwise required in condition of approval 5. We're all in agreement with that one.
We are.
Valley County and the developer agree that species of yew plants are toxic to wildlife, pet, and livestock, and therefore will negate those.
Yes.
The CCNR shall include a requirement that lawns or other irrigated areas within each lot shall not exceed a total of 1/2 acre. That's state law. CCNR shall include a requirement for owners to minimize the application of fertilizers, pesticides, herbicides, and fungicides to protect subdivision wellheads and groundwater except as otherwise required by Valley County. I think that was one of the conditions of approval. The CCNR shall require septic operation maintenance to specify pumping is necessary and at minimum once every 5 years or compliance with manufacturer specifications for similar types. Lots are going to be allowed to share wells if IDWR allows it. County shall erect signs related to cattle crossing or wildlife crossing on Spink Lane and or farm to market. I want to make a statement that this is specific to this CUP. This is not something the county is going to do in any other application unless it's required to do under a CUP. So this is a specialty one-off that we will do this one time.
Didn't we discuss that the county will charge for these signs?
Yeah, in this, it's been, Brian did tell us that he approved the county to actually do this.
Thank you.
Spink Lane improvements will be designed, sequenced, and routinely inspected by a county engineer to ensure safety, operability, drainage capability, and maintenance of access to adjacent parcels. Squires, and those there are some shared driveways. For example, the county shall require that eastern western terminus of road activity sequence will maintain access and adequate stormwater management, drainage, and grading to protect the integrity of the driveways and their parcel access. I believe that this has also been agreed to and is actually a part of the Valley County approved road maintenance and documents, so. Okay, so we've been in agreement on that. Those will be added to the development agreement. And the disputed items we have discussed. Don't think. Agreement with those additions.
Covered all my notes.
Is there anything else that the developer would like to discuss with us?
Madam Chair, from our perspective, no. And again, thank you to the county and the neighbor's attorney for working really hard on this.
I think then that went pretty quickly. So it's always good to have collaboration. I'm glad that you guys met. This is the reason that we could not approve the development agreement. So apologies for last week. I know that that was frustrating, but at the same time, this is our one opportunity to discuss with the developer the things that we require and also to mitigate impacts to the neighbors. And so it was important that we get to this point so that we had something that we all felt comfortable with and that we could sign off on. So,
Thank you, Madam Chair and Commissioners.
all right.
Madam Chairman, can I get a clarification? Am I approved?
As soon as we vote on it.
Okay, so upon the vote, I can commence construction.
Yes. My understanding is yes.
Thank you.
I'm getting head nods.
Once the agreement's signed by you.
Once we all sign, so.
What do we sign?
All right. I have a motion to approve the development agreement, 2402.
I would move that we approve the development agreement for River Fork Ranch with the additions from the disputed list included.
Second.
All right, it's been moved and seconded. All in favor?
Aye.
Like, do we have that available for signature?
Madam Chairman, I do not have a copy of it with the changes.
Okay. We'll make some changes. We'll get that signed. Get that signed today and
We can facilitate that. Could we wait around to do that? Thank you.
we will be here for a while also, so.
Okay.
We do have a session after this, so.
Yeah, that's fine.
a while before we can now.
Okay.
Madam Chairman, can I just thank the commission for helping us get this meeting today and get this resolved? We really appreciate it.
Happy to accommodate, so. All right. Thank you.
Thank you.
Our next item is an executive session. So we will go into executive session 742061F. I have a second.
Second.
Roll call vote.
Thompson, aye.
Bob and I.
Caldwell, aye.
We will be in, and that is the last item on the agenda. So when we come out, we will